All right, everybody. So welcome. Some of you know me. Some of you, for those of you that don't know me, my name is Nicole Bob. I am the owner of Notary Training Network. So happy National Notary Public Day again. If you didn't know, we have a day. We're special. So go ahead, give yourselves a pat on the back because today we are here to recognize and celebrate you. This is a candid conversation. So I know some of you know I'm used to being the one teaching. Y'all are with me through my growth phase because now I'm letting other people teach. So you're not going to hear too much from me tonight. We're going to let the experts on the panel tell you all about estate planning and notarizing trust documents if you want to get into that niche and how you can make it a profitable niche as a mobile notary. So thank you again so much for joining us. This session is being recorded, so please don't take yourselves off of mute. Go ahead and put anything that you have to say in the chat, and we will get to your questions and comments a little bit later as we go through the session. So we are going to go ahead. Oh, my fun fact is I did go hiking through the Swiss Alps in Switzerland. So if you ever get to go to Europe, I definitely recommend going to Switzerland. So that's my fun fact. Y'all can share your fun facts in the chat because if you know one thing about me, you know I like to get y'all networking and interacting with each other. So go ahead. Don't be shy. Drop your comments in the chat and we will go ahead and get started. Make sure you have your pens and your notepads out so you can take good notes because I'm excited to have this conversation tonight. All right, go ahead and go to the next slide. So we're going to go ahead and get started. And first, we're going to be talking about what is a trust. Because before you leave here today, we want to make sure you understand what everything about estate planning is. We are not going to be doing any examples of notarizing any estate planning documents, but you will be able to get a nice, thorough understanding of what those documents entail. So our first question is, what is a trust? Stavon, can you tell us a little bit about what is a trust? What does a trust do? How does a trust work? And then Tara, when he's done, I'd like to hear from you as well.
Yes. So the question is a good one because I think just going back to talking about demystifying what a lot of these things are, right? A trust is, I'm going to say what a trust is and what it isn't. A trust is not this magical kind of catch-all, do everything that you can think of under the sun device. It is a very, very practical instrument. It's a contract, right? People have to agree to things within a trust, right? And it's binding, right? And so when we talk about what it is a generational wealth tool, generational wealth building tool. It is a probate avoidance tool, right? Meaning it does help to avoid the catastrophe that can be probate court at times. But it is not a tax avoidance device by and large. And I think that that's where a lot of people get things mixed up. It's not gonna, it's not a tax shelter per se. And so although there are ways to enjoy tax savings, it really is meant to guard inheritances, to manage things beyond the grave, or at least have some measure of a better type of control than you would otherwise. And, it's really an instrument that is supposed to be a thoughtful one, right? You have to think things through. You have to think eventualities through. You have to think through, behavior types of certain people that you love. But if you do all of those things, it can be a great thing.
Thank you, Stavon. And Tara, can you go ahead and break down your definition for us, please?
Yeah, so I agree with what Stavon said. A trust is a great tool in certain situations. I tell people, as he said, it's a contract that you basically make with yourself or another person as a trustee to carry out certain wishes and desires as stated in the trust. It is, there are certain benefits of a trust over a will. A will is public. A will guarantees probate. A will doesn't have the ability to be as creative as you are in trusts. It also doesn't provide necessarily asset protection. A trust, a trust agreement, a trust plan does give privacy. So it's never filed anywhere. It's not filed in the court. Only the beneficiaries of the trusts have access to the provisions. It avoids probate. It allows for creativity in passing on the generational wealth that Stefan was referring to. And, certain situations where I use trust specifically is when you have minor children, or you have children who are not financially, fiscally, savvy or responsible with money, or maybe have substance abuse problems. There's a lot of issues, with adult children who have substance abuse issues, and, parents don't want to leave large sums of money to those children because, it doesn't help them. So in order, I have clients who have adult children who have substance abuse problems, and we can use a trust to guarantee that that child has a roof over their head for the rest of their lives, or food on their table, or insurance. So you can put restrictions and conditions on, assets passing through a trust as opposed to using a will. So there's a lot of things that a lot of creative things that you can do to have that kind of control from the grave with a trust as opposed to a will. Not saying it's appropriate for every situation. There are attorneys out there who will try to push trusts, or other financial advisors. So you have to be careful when you use it, but it is definitely a great tool for the correct circumstances.
I love that. So I want to get a little bit more into the generational wealth building piece of it. So before I go back to you, Stefan, Tara, can you kind of tell us what are some different ways or outlets that people use trust for? Like, for example, I've seen life insurance, sale of real property. Can you kind of go into some of the different types of ways that people can establish a trust? And then once she's done, Stefan, can you kind of talk about how the generational wealth is able to pass through the trust from generation to generation?
So, situations where a family that wants to use a trust to pass assets on to family. There's certain situations where you have family homes. So properties that have been in the family for generations, and the family wants to keep that property in the family. So one way to do that is put that in a trust. And as long as you have trustees who are responsible and that you trust, because you want to trust your trustee, they're going to manage and maintain that property to pass on to the family, or allow the family to use that. So that's one really good example of using a trust to do that. The other benefit of using a trust would be that, just an example, let's say you have parents who give outright distribution to a child, and maybe they're not such a fan of the son-in-law or daughter-in-law. When you give an outright distribution through a will to a child, if something happens to that child, then that property goes through their estate, which is usually to their surviving spouse. But by using a trust, you can ensure that the property does not leave the family. It doesn't go to a daughter-in-law or son-in-law, and it passes down to grandchildren or great-grandchildren. So you can put certain, restrictions and conditions to ensure that the person's wishes and desires are complied with after they're long gone.
And I like that you mentioned that. I've also seen where they have a generation skipping trust.
Mm-hmm.
So, Stefan, can you tell us a little bit about how it works to keep the generational wealth in the family if you're skipping generations, and also beneficiaries, and how that works?
Yes. So what you're referring to is a very specific kind of trust. It is one of the few trusts, and Tara, you did an excellent job explaining, the overview of what, distinguishes a trust from a will in terms of benefits. But a generation skipping trust is one of those trusts where you can see some sort of tax benefits, especially if you included with the 529 account, the school account that folks like to use to fund education. But going back to the general proposition of what is or how does generational wealth pass via a trust, right? So Tara talked about protecting items from probate. That's a huge thing. I often say to people, look, depending on what kind of situation you're in, probate can be worse than the IRS, right? And we all know how invasive an IRS audit is. And the thing is that probate adds a different element onto that because you have, and Tara alluded to this, you have family bickering that can occur at any given moment. It's very ugly when family members can't agree and they bring the mess to the probate court. There are objections all over the place. And guess what? As the family is fighting over somebody's asset who has passed away, guess what's happening to the value of the estate? It's diminishing. Guess what's happening to generational wealth? It's diminishing. It's evaporating, right? And so that's the risk that you run when you leave things up to the probate process. The next thing that a trust does to foster generational wealth is that it really concretizes your wish for an asset. So one of the things that really pulls me into this legacy planning, estate planning world is the beauty of being able to put a sentiment along with an asset and make sure that that thing is carried out in the spirit of what you intended. So what I mean by that is, great example. When I was about to go to college, my mom, she had a Toyota Camry that she bought, and she was going to school. This was her car that she did all of the things with. And she looked at me one day when I was like maybe 6, when I was in the back seat, and she said, "Stevan, I'm going to give this car to you one day." Right. And it actually came to fruition later on, exactly how she planned it. Right. I was going to school, I was leaving the state, and I needed a vehicle. And so the beauty of a trust is that all of the assets that you look to provide for somebody else, or you're looking to provide for somebody else, you can safeguard those assets under your directions as a trustee, whatever, as a grantor when you're creating the trust. And whatever you put down on paper, that is the blueprint for the direction of your assets. And you want to be very careful about what you put down. You want to make sure you cross your T's and dot your I's. And so that is the benefit that a trust gives you, talking about that extended reach beyond, just your immediate kind of power. The last thing that I want to say about how a trust transfers generational wealth is that there's a very, very, very strong accounting feature in trusts. And so what's happening in a lot of different communities is that folks get stuff either informally or formally, and you don't know what happens to it, right? It turns into what we call unproductive property, right? People don't know what they're doing. They don't know how to manage it. But the best part about, what's happening in that phenomenon, and I guess it's not the best part, it's the worst part. The worst part is that there's no tracking of the asset's development, right? It's like, okay, the asset may have been worth $500 and I'm just using a low number, $500 in 2023. All of the foolery, all of the mismanagement, unaccounted for, now the asset is worth $100 in 2025, right? A trust is designed to capture all of that progress, quote unquote, so that there are actually some kind of triggering systems or alarm systems when it comes to very, very important property. And so those are the things that, a trust does to protect generational wealth.
I love that. So if y'all are taking notes, make sure you write in your notes if you don't have a trust, or if you're thinking about getting a trust is basically instructions for what you want to do with your assets. So can you go to the next slide for me? Okay, so this one was good. So we're talking about generational wealth. Now let's say that 500 got flipped and we did manage it good and it turned into 100,000 because mama and grandmama and granddaddy knew what they were doing. Can you talk to us, both of you, about how it works when you want to take some of that money out of the account? And then Tara, can you cover the retirement accounts? And Stephon, can you cover the investment accounts and maybe go over some differences between the two?
Tara, you can go first.
Sure. Well, there's certain rules with regard to retirement accounts. I'm not a financial advisor, but with retirement accounts, you have to, I believe you can't take distribution before 59 and a half, or else you pay penalties. You have to, those are meant for retirement. So as you reach retirement, then you can contact the institution and then make arrangements to either withdraw certain amounts of money, or you, at some point you have to take what's called as RMD, or required minimum distribution. So the government requires you to take a certain amount of the account as distributions over the balance of your life expectancy. And of course, you have to pay taxes on those withdrawals. So when you have a retirement account, that's basically all pre-tax money. That's pre-tax money you've put in during all the time that you've worked, or all the time that you've lived, and you put that money in pre-tax. So it's grown tax-free for however many years. So, if your cost basis, the money you put in is, $100,000, but it's grown to be $150,000, you're going to have to pay income tax on that $50,000 as you take those distributions over time during retirement. If you do have an emergency, I believe the IRS does have specific criteria for specific emergencies where you don't have to pay a penalty. I don't know what those are. I believe that emergency medical expenses could be one. But for the most part, if you take money early from the retirement accounts, you're going to have to pay penalties on top of the taxes that you owe. So, and that's usually done through the financial institution, whether it's the bank or the investment company, or your financial advisor would help with the client, the documents necessary to set up those withdrawals.
Yes, and for my part, I think it's very straightforward, and just in terms of what a trust can do to protect, investment accounts, retirement accounts. The thing is that I think it was alluded to earlier, just in the sense that a trust can be a recipient of life insurance funds, for example, right? And these things are done because of the issue that a lot of people run into when it comes to who can I select as my beneficiary, right? Usually, a lot of plans don't allow you to designate a minor as a beneficiary. And so the issue is, okay, I know that I need to name somebody who can benefit from this or who can receive the proceeds. However, the person that I want to, inherit it can't list them. Let me go ahead and list somebody who is close to me, right? Who I know I can trust them and take them for their word. And again, I don't know if life insurance proceeds going to a trust is one of the slides on here, but I think this alludes to it. The trust is able to take those proceeds. Usually there's some conditions to it, but the trust can be the recipient of the proceeds instead of the horrible situation that a lot of people face, which is, hey, I gave my cousin Ricky $100,000 from the proceeds of my policy, and okay, where's Uncle Ricky now? Uncle Ricky done took your money and left and is gone with the wind, right? The trust makes sure that those kinds of situations don't happen because the trust is a contract. It has guidelines, it has that blueprint, and it allows you to determine what's going to happen with things, with the money coming from your retirement account, from your investment account, etc.
Yeah, and just to add to that, I know this slide is talking about notarizing financial documents. I would point out that, as Stephon had mentioned, oftentimes, most of the time, we name the trust a revocable living trust, the beneficiary of life insurance proceeds, just because, like he said, we want to get that put into we want to get those proceeds in the trust to get that protection. Protection from either, minors who don't have the ability to manage money, people who are just not financially savvy, aren't responsible for money, or let's say special needs, beneficiaries, special needs children who are relying on government benefits. That's another big area where we use
Huge
trust
one.
so that they don't lose their eligibility. But when we get those documents, typically Maryland does not. Most of the beneficiary forms, I would say, for life insurance do not need to be notarized, but there are certain states, and it has on the bottom of the documents, I believe Massachusetts is definitely one, California is one. So if you're getting people who I think have policies from those states, or they're dealing with those states, those do require notarization. But life insurance, change of beneficiary generally just need witnesses. But the ones that do sometimes are the financial accounts. So like the Fidelity or Morgan Stanley, Merrill Lynch, a lot of those beneficiary forms do require that the owner's changes in the change of beneficiary form are witnessed and notarized. So that's notaries definitely come into play when we're dealing with change of beneficiary forms more often than not.
So I hope y'all are paying attention, because she's telling you who you need to network with. Fidelity, Morgan Stanley, anybody that has those investment brokerage firms, and anybody that deals with beneficiaries, that's who you need to connect with so you can get them to notarize their forms. Now, I'm going to ask for myself and any other inquiring minds that might want to know, because y'all are talking about minors. What exactly is a trust fund baby?
Well, I mean, a trust fund baby is generally someone who receives a significant amount of money in trust that either they have full access to at a certain age, or they have a trustee who is very liberal with making distributions. So a lot of trusts give very liberal discretion, a lot of discretion to the trustee. So it's really important to pick a responsible trustee, because if you have an 18-year-old kid who has $1 million in trust, you certainly don't want them to be the trustee of their own money, but they certainly could at age 18. They're adults under, and the laws in the eye of the law of Maryland, they're adults when they're turned 18. But I tell my clients, you don't want an 18-year-old in charge of $1 million, because they're going to go blow it on a car that depreciates and is worth nothing in 5 years. And now they've blown, $50,000 or $100,000 and it's gone. But you also want a trustee who's going to be responsible in making decisions. So if that 19-year-old says, hey, I found this great, this great new business, and my friend wants me to invest $100,000, and it sounds really great, and we're going to make a lot of money, and the trustees like, okay, well, let's do our due diligence. Let's look into this. And it turns out to be a scam. That trustee is going to say, nope, I don't think that's a good use of this money. I'm not going to distribute anything to you for this use. I'll give it to you for education. I'll give it to you for vocational school. I'll give it to you to maybe a down payment on a first house, or to get a reasonably priced car to get yourself to and from your job. But so those are the things that you want to consider when you're thinking about a trustee, and you want to avoid the quote trust fund baby.
And
Yes.
something we weren't going to cover it, but I think it's important to mention, especially because we were just talking about fraud at the conference last month, the special needs trust, because notaries often get the question, what's my fiduciary responsibility for reporting something that sounds suspicious? So I know special needs trusts are one of the lesser common ones. Can you touch on that a little bit, for if we do go out and we do find ourselves in a situation where something questionable is going on, and it could possibly be they have power of attorney and they have all the correct paperwork and documentation necessary, but they might be some signs of financial exploitation. Can we touch on that a little bit?
Yes. So I can actually go ahead first on that one, because I think as I was talking about at the notary conference, you have this issue, and I'm not sure that the law is as caught up with it as it needs to be, but you have this issue of ghost guardianship, meaning that, you know, there's some level of duress going on, undue influence, coercion, and then you have a ward, right, or somebody who's being taken care of, who is a victim of financial exploitation, neglect, abuse, whatever have you. And so I think the notary, as we were talking about at the conference, I think the notary plays a very, very special role in literally being the gatekeeper when it comes to determining, just on a superficial, you know, look me in my eyes kind of basis, if somebody is the victim of undue influence, or if, even on a more simple you know, tip, if somebody clearly does not have the capacity to make the decision that they're trying to undertake. And so, you know, I think one of the examples that was given before was, you know, a notary asked a woman who was surrounded by her family, you know, who's the president of the United States right now, right? And at the time it was Barack Obama, but the person who was going to sign their life away on the dotted line couldn't even name who the president was at the time. Somebody who was clearly not fit to be making, you know, monumental decisions that they're being pushed to make. And so the notary is really the first line, or maybe the last line of defense when it comes to either diminished capacity issues or some kind of undue influence. And so, you know, really special role that you guys occupy in that regard.
Yeah, I definitely agree with that. You know, from a perspective as an attorney, there, you know, not often, thank goodness, but there's certainly situations where we come across where people are bringing other people in to try to, you know, create a new power of attorney or change their will. And when you're talking to them, you know, you get a sense sometimes that this is not on the up and up. And when you take them alone, and we have a right to take them alone into the office and say, you know, we want to make sure this is what you want. Or if, you know, you're sensing that this person is not competent. I mean, there have been many times during my career where I say, I'm sorry, I can't witness and notarize this because, you know, in my opinion, this person's not competent. They don't know what they're signing. They don't understand it. So from a professional standpoint and just, you know, morally, I'm not going to witness and notarize something that I clearly know this person has no clue what they're signing away. And especially when it's an important legal document, you know, it's something definitely to look out for.
And I do have one more thing to say. And so another thing that I think everybody should watch out for, and you know, sometimes they can be perfectly valid, but anytime that I get a deathbed will, I run the other way, right? And the deathbed will is, hey, my relative is about to die in 24 hours. Can you sign this last will and testament for them? I'm sorry to hear that. However, my license does not permit me to, you know, be a risk factor in this situation. And I know that it's something that's just going to end up biting me in the butt. And so as a notary, right, I can only imagine the situation, you know, that is imposed upon you in a deathbed situation. And so I would just say, you know, that's one of the factors. And again, people need it. It's a real thing. But, you know, just for the sake of making sure that, you know, things don't come back to you, I would say watch those kind of situations as well.
And that's a good point that you mentioned, because one of my notary students had a situation where a handwritten will got questioned. So can you this will be the last point before we go on to the next slide. Can y'all kind of touch on what a handwritten will versus a will that's actually went through an attorney to be prepared, and what maybe some of the red flags might be?
Yeah, so in Maryland, you can have what's called a holographic will. A holographic will is a handwritten will, but it follows the same requirements as any other typewritten or will prepared by an attorney. It has to be in writing. It has to be signed by the testator, and it has to be witnessed by two independent witnesses in the presence of the testator, and they have to see the testator sign all together. So if it has those requirements, then it could possibly, it could pass muster and be admitted to probate.
Yeah, no, Tara, you covered that perfectly. There's nothing more to add to that.
Thank you. Perfect. All right, so let's go on to the next one. And I'm excited about the next slide. So I know both of you use mobile notaries, and this is why networking is important, y'all, because Tara, one of her employees from her firm actually reached out to me to be a mobile notary, and I've been following her ever since. So Tara, if you can go ahead and plug your She Shed real quick.
Oh.
Am I saying it right?
Yes. So were you in the She Shed?
I'd be popping in and out of the She
Okay,
Shed.
yeah. Yeah, so we recently we had a one-car garage in the back of our office, and we were kind of like busting at the seams for space. So we decided to renovate the garage, and it has become the She Shed. So that's where moved my office out to the She Shed, and we have a TV, so we can do Zoom meetings, we can have team meetings, we have a big conference table. So yeah, we were really excited about the She Shed. So yeah.
And how can they get on your newsletter?
Yeah, so to get on the newsletter, we have our website. It's www.frameandframe.com, and you can sign up. If you do contact us, you can sign up to be on the newsletter and we send it out bi-monthly, and it always has really good information, both legal information and some pop culture. So, we spread some good information. Excuse me, I'm trying to hold my cough from my cold. But one of the ways that people can, especially notaries, I think, working with estate planning attorneys is a great way to network, because, we're often needing mobile notaries. We have people who are housebound. They can't get to our office. We have people that are in nursing homes. They can't get to our office. They might be in a hospital. And, we can't always send our staff out to notarize documents. So we're needing the services of mobile notaries to get documents signed by our clients. So that's a really, really great relationship for you to build, is with a few really good estate planning attorneys, and you can get a lot of work from that.
Hey, Erica. Welcome to the party. We're going to put you on the spot. So we're talking about networking. So can you give us your best networking tip and customer service advice for mobile notaries that may want to work with estate planning attorneys?
Sure. So thank you, Tara, for tag teaming for me there. Tara was pitch hitting for me while I was at the PTA meeting. But the best way to build a relationship with an attorney is obviously, do a good job. Do what you're supposed to do when you're supposed to be notarizing something correctly. Make sure you're getting the proper IDs. Make sure you're doing the check on the person to make sure that they're knowingly and voluntarily signing the document, because obviously reputation is everything. And you're kind of an extension of the attorney. You're representing that attorney when you sign that document in some ways. So if you get around and you're good at your job, then they're going to recommend you to other attorneys who need mobile notaries. Excuse me, talking too fast. Slow down. Mobile notaries, and also, for them just to have an extension of their office, like Tara was saying. We can't always send our staff out. We don't have exponential staff that we can send out. And it's great where we say, okay, we have one witness, but we need a second witness to do the notarization. So it's a great way to network with us, because we always need notaries, most everything we do.
And then Stevan, I networked with him through, I think, honestly, I don't even remember. I think it was because I seen him working with a notary on the West Coast. And I was like, I'm on the East Coast, so you need to come on to work over here. Where you at? I probably said it just like that.
No, and I've responded exactly to that, and I agree with everybody, and what they've said on the panel. Just for my purposes and my needs, right? The thing is that I don't know what's happening, but it used to be, in my memory, I don't know if this is like a pre-COVID thing, but it used to be that you can go to any bank and get something notarized because they had somebody, on call or whatever, or you can go to like FedEx, whatever. The obvious difficulty with that is that, again, I don't know what's been happening, but banks are just not staffing notaries as much as they used to. And so literally you have to have a favorite bank now that you go to get it notarized if that's an option you wanted to exercise. Another thing is that, usually what I've seen is that folks combine their secretary needs and their notary needs. So a secretary might double as a notary, and that's okay, but there are times where that just can't happen, right? And so the mobile notary is really, I think, an innovation in the field because, there is nothing that beats the convenience of saying, hey, I know I need a document notarized. I need a notary to come to the office. I have clients here. They don't, necessarily want to meet at a central location where there's a notary, right? That's not the most professional look, right? You want to have everything done at your office. You want to have somebody who is very personable, great customer service skills, can leave that impression for your business. And ultimately, you want somebody who's dependable, like everybody else was saying on the panel, who once they stamp that thing, that's a great notary right there.
So I just want to add, because I work at the bank, so a lot of banks did close because of COVID. And then now you have to have appointments. And then I don't know if y'all watch the news, but UPS is going through a lawsuit because they're overcharging. So once again, networking, go to your local banks, especially if it's a bank that you bank with, and let them know, hey, I provide mobile notary services, because some people honestly don't even know what a mobile notary is. They don't know that service exists. So I want to pose the question and hear from each of you. Let's talk about, Tara, can you cover professionalism? Erica, can you cover customer service? And Stavon, can you cover networking with smaller firms and solo practice attorneys? How should we be addressing you? What type of conversations should we be having to start building those relationships?
You want me to start?
Yes.
Okay. So professionalism, I would say, I think as Erica had alluded to, that if we hire a mobile notary, the clients, all they know is that they're having someone that's associated with their office coming out to notarize and witness documents. So, you are in effect representing our firm. So, you should be professional. You should be professionally dressed. Be courteous and friendly to the client. Try to answer questions, not legal questions, but kind of questions about how the process works and what they're supposed to be doing, what happens next, the documents will be, sent back to the attorney's office, and then someone would be following up. So just really professionalism is just general, common courtesy, friendliness, and dressing appropriately, acting appropriately, and just making a really good impression, as if you are, part of the business that you're representing.
Thank you. And Erica?
All right. So customer service wise, they kind of go hand in hand with professionalism, because obviously these documents there's a solemnity. I'm going to screw up the word, but there's a solemn nature to these documents. This is somebody's power of attorney, which gives them the rights to, make financial decisions, healthcare decisions, last will and testament. These aren't just a contract that people have, but this is going to be something that is going to affect these people's lives. So taking it with some seriousness as to what you're notarizing, but also making them feel comfortable. So there's a fine line between the two of them. You want to be, happy, light, and airy, and have that jovial impression to them, that but still professional and understanding what you are going to be notarizing for them. Now, obviously, you can review it really quickly and see what it is. You can see that it's a power of attorney. It says it right at the top. So it's not like you have to read the document or do anything that's not in compliance with our professionalism as notaries. But you want to make sure that you are looking them in the eyes, you are giving them, your full attention, and that you're not just treating them as a number. Because again, and I will say this, Tara said it, I said it, you are an extension of that attorney that you're representing. So if you want to get business from that attorney and you want to have the repeat business from that attorney, you're going to want to make sure that you get good feedback, because I guarantee you the client will go back to that attorney and say, that was a terrible experience with your notary. They were not professional at all, or they were not dressed appropriately, or they didn't even smile at me when I said hello to them. So that's pretty much the ABCs for me on customer service.
Yes, and for me, when it comes to networking, I think, everybody wants better business. Everybody wants volume with their business. Notaries are no exception, right? And so it just, it is incumbent upon the notary to know what parts of the legal profession, right, are the most notary intensive. And so, just from my experience, right, we're talking about wills, we're talking about trusts, definitely, notary intensive. But, a lot of people will overlook the probate process as requiring notaries. Notaries are definitely needed, both in the, probate side, just the administrative portion of it, as well as the probate litigation side. Because, one thing, when you're talking about settlements of any nature, right, usually those have to be witnessed, and just for great measure, they need to be notarized, right? And the thing is that, there's a slew of situations like that when you're talking about trying to get heirs to agree to things on paper, things like that. And then, when you're talking about closings, settlements, real estate, right? All of that is probate adjacent in some kind of way. And so, obviously going for the real estate work within the law, definitely a jackpot, but also, some of these other more underlooked parts, such as probate litigation, and of course, estates, wills and trusts.
And I'm so glad you mentioned that, actually, because I was listening to something the other day, and I can't remember the exact numbers, but notaries try to go after marketing real estate and mortgage and real estate closings and stuff a whole lot. But compared with all of the things that have to get notarized, it's actually a really small percentage of the industry, mortgage specifically. So I'm glad to hear there's other opportunities for networking. All right, can you go to the next slide for me?
Yes.
Okay, so legal aspects of notarization. So we have 3 points, and I will let y'all pick and choose which one you want to address. But for the unusual request, I would love to hear some stories of some crazy situations that y'all had with notaries. Tara, you can go first. Pick one.
I guess I would say signing as a trustee. Signing as a trustee is just similar to signing, signing a will. Generally with my trusts, I have the trustee sign. They're called the grantor because they're granting the powers to the trustee. So a lot of times they're the grantor, the creator of the trust or the trust maker, but they're also the trustee, appointing themselves as the initial trustee of their trust. When they become incapacitated or pass, then that passes on to a successor trustee. But generally, they're going to sign as both the grantor and the trustee. And the witness will witness both the signature. I usually do two separate signatures. So they sign as a grantor, that's witnessed and notarized, and they sign as a trustee, and that's witnessed and notarized. So that's kind of a nuance as a notary who's never done that before. They might not say, oh, well, wait a minute, he already signed, but he's signing in different capacities. Similar to what Stefan had mentioned in probate, you sometimes you're signing a document like an agreement. You're signing that as an individual, so maybe an heir to an estate, but you may also be the executor or personal representative of the estate. So you're signing in two separate capacities, and you have to sign in two separate spots, and both normally would have to be notarized. So just be aware of that.
Thank you. And Stevan?
Yes. So this is not exactly related, but kind of related, and I just want to, just as a general kind of education about trustees. So what Tara explained is that, you know, there are different capacities, and one of the issues in the estate planning world is that people are not properly funding their trust, right? They're not realizing that, hey, if I am both the grantor and the trustee, in the case of a lot of people, when they choose to do their planning, I'm not one and the same person legally anymore, right? Like I am me, myself, the individual, but the minute that I have anything to do with my trust or my trust assets, I put on a different hat. If I'm the trustee, then I am me, comma, as trustee. And, you know, one of the things that people are doing to their detriment is that they're forgetting that they have that extra capacity that they, you know, have to officially identify as. And so that's just one thing that I wanted to just throw out there. But Tara, she covered everything perfectly.
Perfect. And then can any of you touch on stock certificates? This goes back to when we want to withdraw some funds out of those investment accounts, but instead of it being cash, it may be invested as some stocks. So how would that work if we wanted to take money out of that trust?
So taking money out of the trust, or just notarizing general stock certificates. So
using the stock certificates to take money out of the trust.
So that's going to be a catch-22 for some notaries, because I know that, you know, those stock certificate, any stock certificate withdrawal forms are very complicated. And generally that's when you're going to have a person coming to you as a notary saying, did I do this right? And that is a trick question. Do not answer that question. Send them back to their attorney or whoever sent them the document, because that's going to be the trick question. So that's the big like red flag, is do not do anything with that document if they don't know, because they're unreasonably complicated for no reason. But as far as, you know, making sure that, you know, if they say, you know, I'm signing as the trustee, well, is there a trust listed as the account? You know, are they listed as the trustee signing as, you know, the person who's going to be withdrawing the funds? Just those types of things we can check for and make sure they're correct. But again, if they have any questions, red flags, send it back to whoever helped them to obtain the document at that point. But to address your unusual request, and it's not really totally unusual, I find it's uncommon. But my husband and I, before we were married and we moved in together, we had an occupancy agreement where we said who was going to be doing the chores in the house, who was going to be paying what bills. And we went to our local bank and had it notarized. And the guy looked at us like we were crazy, but we used it, you know, to keep each other honest as to what we were doing, who was taking care of the cat. So all good there.
No, I actually think that that's very responsible, because, you know, in a divorce situation or whatever, right? It's like there's just so much, you know, tension and all that kind of stuff. If you have a document like that, it makes it, you know, 10 times easier to work with, because the parties actually agree to things, right? So look, that's excellent.
And do Stevan or Tara, do y'all have any unusual request stories to share? Or any red flag stories to share?
So I don't think that I have any red flag stories. I literally, when I sniff out a bad situation, I'm just like, I'm not trying to deal with it. So I don't run into too many things that I have to go through to realize that, like, hey, this is not, you know, this is not kosher. So
yeah, I was just gonna say, like Stevan, you had mentioned before, kind of like the deathbed wills, you know, that's probably one thing that, you know, when people, if they have one child and it's only child, and, you know, they're trying to get documents signed because mom's going to a nursing home or a hospital and there's only one child, so that child's going to do everything anyway. It's not as big of a deal. But if you have one child bringing in mom or dad to change documents, and basically everything's now being left to that one child, and they're doing it, they're like, we have to get in tomorrow, then yeah, I just like Stevan said, just run, you know, we run away from that, because really there's no reason that, kind of as we say, their emergency is not our emergency. That might sound bad, but because either they failed to plan ahead, or, you know, either somebody's doing something that they're not supposed to be doing, or they just failed to plan ahead, that doesn't make it our emergency that we have to, you know, create stress in our office to rush somebody in, you know, by 5 o'clock, or make our staff stay till 6 o'clock so somebody can sign a document. But so when there's a rush and they say, oh, we have to get this to today or tomorrow, then, like as Stevan said, you know, you got to be really, really careful in those situations, because usually something funny's going on. Maybe not 9 out of 10 times.
And I do have one kind of like funny situation that I just thought of. So a colleague of mine referred a case to me, and it was a probate case, or a case that had gone through probate to some extent. And my friend or my colleague, not really understanding probate, was just like, hey, Stevan, you do this? What's happening? And so I called the guy, and it turned out that he had a deed, right? But there was some kind of mishap in probate court where either heirs had been left out or omitted from the probate process, and they had to, you know, supply those names, all that kind of stuff. Now, where things went awry is that the person who, I guess, wanted the probate process to go differently, they said, we have this deed, Mr. Bush. Come on now, can't you just, you know, sign it off and create a new deed where you leave off the people and we'll just handle it later? Now, I'm at the top of what will definitely be a very sticky situation for a notary, because if I do create this deed, right, where literally there is no chain of title, or it's broken in such a way where it's just like, this is going to come back to me on my license, and me with the weight of my title, I bring that to a notary, I'm effectively putting that notary in jeopardy in the same kind of way that I'm in jeopardy, right? And so definitely want to watch out for that. I'm not sure. I'm thinking that the way to avoid something like that, because that's really not a fault of the notary if an attorney is bringing it to them, because they're going to trust the attorney, right? But you want to make sure, as was said at the conference, that when it comes to special instruments like deeds and things like that, titles, things like that, that you have another kind of magnifying glass to be able to filter out the bad stuff.
I do, while Stevan was talking, I did remember a situation. I did have an interesting case just recently that you have to be careful of. So as I said, when we first started this presentation, that the requirements of, when we were talking about holographic wills or any will, under the statute in Maryland, the testator has to sign in front of 2 independent witnesses, and the witnesses have to view the testator signing, and they all have to be in the same room to confirm and verify each other's signatures. So I had a case where the decedent, the person who died, the decedent, his neighbor had come to find out he had this will that he presented, and the will left everything to this neighbor. And the decedent had all these cousins, had a live-in girlfriend he had lived with for 20 years, but this will left everything to this neighbor. So obviously the whole family was up in arms about it, because we knew that there's no way that he would have left everything to this neighbor. So we got this will, and we ended up calling the witnesses to depositions. So we scheduled depositions of the witnesses, and they testified not in the same room. So each of them testified in their separate depositions. Come to find out, when we questioned them, one of them admitted that the testator apparently maybe signed, the guy brought him to a parking lot. They all met in the parking lot. The testator supposedly signed the will in the car, and then the neighbor gave the will to the witnesses, and they were on the back of the car witnessing the client signing, which they didn't witness. So he never saw the older gentleman sign the will. He was just given a document. He signed it on the back of the car. And then come to find out, the other witness, who was a woman, she ended up being the neighbor's girlfriend. So when we took the deposition, so if you are a notary or a witness and you're not doing it properly, you would be subject to being called in for a deposition by an attorney's office, and under oath, you would have to testify as to exactly what happened. We ended up settling the case, so it never went to hearing on whether this will was ever going to be accepted, but we worked out a settlement. The neighbor did not get the entire estate, but that's a situation where you have to be careful to follow the rules and follow statute with regard to witnessing, actually seeing the person sign, and everybody acknowledges their signatures.
Oh, I'm loving this conversation. Stefan, can you go to the next slide for me? Because this is a perfect leeway into trust and wills. Quick plug, not really a plug, because I'm gonna tell y'all, I used to be a process server in my early notary years, and I used to have to go hunt down those heirs to those deeds, and they didn't want to be found. And I got called all types of things other than my name. So, it'll give you some thick skin. It surely isn't for the weak. But if you want to add process server to your list of things to do as a notary, there's an opportunity for you. So I know we've already kind of been talking about trust and wills, but Tara, can you talk more about why witnessing and properly witnessing a document, or having witnesses sign a document that you have to notarize, is important? And then Stefan, can you cover the difference between the legacy planning and the estate planning? And then Erica, if you're able to talk a little bit more about how the depositions work, or if Tara and Erica, if you want to tag team on that, and how that deposition process would work.
Yeah. So, it is really important to properly witness documents. If somebody, if you're witnessing or notarizing a document, the person can't sign it in another room and then bring it to you, and then you sign saying you've witnessed that or notarize it, because you haven't witnessed it or notarized it. The point is so that you can prove, or it's kind of self-proven when you have a notary in many cases, that this person was present. You've acknowledged, you've gotten proof that this person is who they say they are, and that they have acknowledged the document and they've signed the document. Because otherwise, that's when you get situations like the one I just talked about, where you're in court because either one, the gentleman didn't sign the will. We weren't sure if that was his signature. Two, nobody was sure if he, what it actually came out to be. What we think happened was he had done a real estate deal with his neighbor. So we believe that the decedent thought he was signing a contract of sale, because he had talked about selling a piece of property to his neighbor. And I think they had worked out a deal, and the decedent thought what he was signing was a contract for the neighbor to purchase the property. So it came down to, he didn't know that he was signing a will that was just leaving the property for free to this neighbor. So there was, to prove, so there's an element of proving who signs it, what they're signing, do they know what they're signing, and then acknowledging that that is the person who signed it. So, we've had other situations where it's been, Erica can talk about this, where we had car titles that we clearly were forged. They were not the same signature, and we've had to hire handwriting experts, to be potential expert witnesses to testify that this is not that person's signature. So, witnessing and notarizing, it's just really important to make sure you comply with the requirements, to make sure that you cover yourself, because you don't want to be in court, and we don't want you to be in court. So.
Y'all definitely have to be at the fraud conference next year. It's going to be on October 8th, 2024, because there's a lot of with the fraud moments here. We had a handwriting expert as the keynote at the conference. That's why I'm over here laughing, because it's like you're talking about everything that we literally just talked about at the conference.
Yep, it happens all the time.
Go ahead, Erica. I'm getting too excited.
That's all right. You're fine. I've got children running around screaming, so it gives me time to kind of calm them down. But as far as depositions go, basically what we have had happen, and I know in our office, our associate has done it, where they will pull the notary in because it's a very easy way to self-prove a will, as Tara was talking about. They're signing under oath that they are knowingly, willingly, voluntarily signing this document and that you've witnessed it. So they're going to call on the notary and say, do you remember this person? Do you remember that they signed it? You're going to pull out your book. Hopefully you have your book. Please have your book. You're going to pull out your book and you're going to say, yes, I had this person. I viewed their ID. They, I didn't have anything that made me feel uncomfortable and I signed it. But if you can't do that, then you're going to potentially face an issue from the judge going, why did you notarize this document? Why did you even go forward with this? But back to depositions, you're going to have to take time off to sit down, and you're going to have a nice conversation with myself, Stefan, or Tara, as to, why you did something that you weren't supposed to be doing something, and then potentially have to have that read in court in front of everybody. And it's a public record at that point. So we can pass that document around as reference points. And as Tara pointed out, we've had situations where, we've had forged signatures, that were on car titles. We had one on a will that I think Tara forgot about, where it was the boyfriend.
Oh yeah, I did forget about that one. Yep.
There was a boyfriend that witnessed the will, and the ex-husband of the girlfriend or whatever it was, but it was like they would never have been in the same room together ever in their lives. And we had to call in the witnesses to have them testify to prove that they would never, ever be in the same room. They would have never witnessed the will, and it would have never happened. So it's kind of embarrassing. It's scary. I wouldn't want to be called as a witness. I would not want to be deposed, and I'm an attorney. So it's not something that every day you would want to do. Because again, it's going to be a couple hours of grilling. And especially if you have somebody like in our office, Katie, she's going to take you out. She's not going to take any prisoners at this point.
And Stefan, before you answer, I just want to play devil's advocate real quick, because the three of y'all are attorneys. I'm not an attorney. I think I wanted to go to law school at one time, but I was like, I don't like arguing no more. What about when you have when you have attorneys who aren't working and holding up their ethical standards, and they have notaries doing stuff that they're not supposed to be doing?
Luckily I have not had, I've seen some unethical behavior, but fortunately I haven't had that issue come about with regard to the use of notaries by an attorney, not that I can recall.
Okay, because it's definitely in the news. I share those articles in my weekly newsletter.
Yeah, so I'm going to be frank. The thing is that when you're talking about the theory of the practice of law and you're talking about what happens on the ground during the practice of law, there have been, so one of the things that I usually see is that, an attorney might have a notary in their pocket, so to speak, right? Somebody who, hey, this attorney knows that they need a crucial document signed off on, and they know that usually the court is not going to question the notarization on there. And it's like, hey, just rubber stamp it so that, it can have the official seal of approval. I think notaries have to watch out for that, right? Just kind of an attorney asking of you to unflinchingly sign things. One of the things that I love when I go to the bank, whenever I have to get things notarized, just on a personal level, is that, you know, they always make sure they say, Mr. Bush, what is this? Right. And I say, oh, it's an affidavit for such and such. And they say, okay, where's the X? Where's your signature? What's the date? Let me see your ID. And they write it in their book. Right. The writing in the book is one of the most essential recording acts that you can do. Right. And so, but also making sure that you know that you're not just signing things at the drop of a hat without any kind of inquiry from you. Like I said, there's definitely, and I've observed it, a practice of, hey, I got this notary in my pocket. Don't worry about it. You know, I'll get it notarized. When the underlying document, it you know, wouldn't pass muster. So I would say, you know, watch out for that. It's definitely great to have go-tos and partnerships with attorneys, but you don't want that relationship to turn into something where you're unflinchingly signing things.
I like that. All right, and if you can go ahead and close us out. So just give us a quick synopsis. No, go back to the other one.
Sorry.
Give us a quick synopsis of how trust and wills work together, and then what's the difference between the legacy planning and the estate planning?
Oh, is this just for me or is this from everybody?
Just for you, so you can close us out on this one.
Okay. So, you know, just in closing, the will and the trust, they play kind of a co-equal but not so co-equal function. The way that my office likes to look at you know, wills and trust is that the will is actually the device of last resort to catch whatever may go wrong in the trust agreement. The trust, if properly planned, is the thing that is your first defense as to what happens with your estate and your trust assets. And so the way we use it is like trust, you know, will, power of attorney, kind of like the sandwich or the patty, the beef patty in the middle that, you know, has something to do with both of the worlds. And so the difference for me, at least, between legacy planning and estate planning, as a Black man, I bring my culture to the planning process. And I think when you're talking about legacy versus estate planning, there's a certain kind of coldness or lack of cultural competency that is assumed by the titling estate, right? But when you're talking about legacy planning, you're talking about really investigating family dynamics, going beyond and above the form, right? With whoever you're dealing with, right? Understanding what certain maybe cultural ideas there may be associated with certain concepts, right? So understanding that, all right, there may be a history of abuse in somebody's family dynamic. How do we protect against that, right? When I find that people engage in estate planning only, it's a matter of how do I place your assets and not really a matter of how does your scheme fit in the overall family dynamic such that we can avoid foreseeable problems.
I love that. And then Tara and Erica, did you want to add anything else to legacy planning versus estate planning?
I think Stevan said it perfectly. So nothing to add.
All right, take us to the next one. All right, so this one, I really just want us to go over some of the terms because we've mentioned them a lot. So, and I'm hoping that everybody that's watching and listening is taking notes. But just in case they haven't been taking notes, can y'all just pick one and just go down the line? Tara, you can start with what's a grantee and anything else you may want to add to it for some of the common terms that we might see when we're notarizing these documents.
Sure. A grantor is generally going to be referenced into a trust. So a grantor is the same as a trustor, a grantor, a settlor, or a trust maker. So the grantor is giving something and the grantee is receiving something. So in a deed, you usually have the grantor is giving or transferring the property to the grantee who is receiving the property. So that would be the most typical documents where you would see grantor and grantee.
All right. And then, Stavon, can you talk about irrevocable versus a revocable trust?
Yes. So the revocable trust is often called the living trust. And the difference between irrevocable and revocable, kind of in the name. Revocable, you can change it, amend it, take it back, whatever. The irrevocable trust, you can still do all of those things. However, it's a lot harder to do so, especially if you have the trust tethered to certain kind of assets, such as insurance, life insurance proceeds. So certain kinds of trusts, such as the irrevocable trust, are the ones or the devices that can actually inherit certain kind of public benefits, things like that, or allow for eligibility of those things. And so the basic difference, without getting too up in the clouds with it, is that you can take back or change, a revocable trust, the composition of it pretty easily. The irrevocable trust, as the name suggests, you can't really do anything that would change it as freely as you would be able to with a revocable trust. And the trade-off is usually that the irrevocable trust can qualify for certain kind of benefits. It can receive certain kind of proceeds, whereas the revocable trust, it's not rocket science why a life insurance company wouldn't want to give proceeds or make, a beneficiary of a revocable trust, right? Easy to change, whatever, let's keep it moving. And so that's the main difference. You're on mute.
Erica, can you close us out with any additional terms that you think that notaries may need to know, and what the impact of an incorrect notarization can have on these documents?
Sure. So to piggyback on Tara, the grantee and grantor you'll also see in deeds. So you'll see those again. It's the giving, the or is the giving, the e is the receiving. You will also see, an executor. You'll see a personal representative. You don't have to notarize deeds in Maryland, or excuse me, wills in Maryland, but you may have a state that does have notarization. Sorry, apologize. You might see, personal representative or executor or executrix. Trix is for a woman, executor is for a man. You may see an agent, a fiduciary when you're getting to powers of attorney. And those are again for health or for financial purposes during the person's lifetime. But I think we've kind of touched on it and danced around. The consequences of incorrect notarization is, number one, the document can be invalid. That's number one. So you have, your first purpose is to make sure that you have validated this document. That's the whole purpose of you being a notary, is you're validating this document. So you may have invalidated the document. The bank or the financial institution or the court or, whomever is supposed to receive this document may not take it. So that's probably the biggest problem that you can face. Secondarily is that you can have some impact to yourself. If you've notarized something like Stefan was saying, you're in the pocket of somebody, if you notarize something without seeing it, you can get called to court. You can have serious consequences for doing something like that, where you didn't actually notarize it correctly. You wouldn't be able to be a notary anymore. That's for darn sure. But the other part of it is, obviously there's some fraud element, where people can commit fraud. They can steal money from a person who's vulnerable. We hear all the time in the news about people who are vulnerable and are taken advantage of, and their niece or nephew have come with them into the bank to withdraw funds for grandma or grandpa or uncle or aunt. And so you're just aiding and abetting somebody who's doing something fraudulently. So that's, in a nutshell, some of the incorrect things incorrect notarization can cause and its impact.
And then I just want to add, because I see the notarized documents as well. In my role in the bank, I actually process the trust application. what are some examples of incorrect notarization? It could be that the notary forgot to put the stamp on the document. It could be that the notary signed the document and the name on their signature isn't how the name is on their notary stamp. So that could potentially invalidate that particular notarization. It could be that the grantors or the grantees or the trustees or whoever needed to sign that paperwork, they probably missed a signature. So now it has to go back and get done all over again. These documents are sometimes transferring tens of thousands of hundreds of millions of dollars. And imagine being with somebody that may be considered elite or uppity or high value, high net worth individual, and they got to come back to you as a notary because you made a mistake because you were rushing and you didn't take the time to correctly look at the document to do that notarization properly. That may or may not be a conversation that you want to have, because now you have to hold your accountability and say, okay, I made a mistake. I need to fix it. So the last question that I want y'all to address before we go
Well,
on.
I have one thing to add to that.
Mhm.
Like one thing that happened recently is we had a document to transfer deed over on the Eastern Shore of Maryland, and whoever they took it to over there to notarize, they had different dates on it.
Mm.
And we had trouble getting this person to sign to begin with. So we had to track them down, and we finally got the document. And then we sent it. Well, my assistant sent it in. I mean, she just sent it to the Register of Wills. And then the clerk said, by the way, we have to send this back to you because they have different dates. So then we looked at it and said, oh my God, the notary had a different date. And I guess, the person, you just sometimes are like, oh, it's today the 6th or the 7th, but they didn't pay attention to those dates.
Yeah.
So now we have to get it done all over again and track this person down.
Yeah, and dates are very important in the sense that your expiration date on your commission has to match what you write on the paper if it has a spot for you to write in what your commission expiration date is. And also the receivers of these documents are sticklers. Because I had one today I had to reject because it was supposed to say 2023 for the year, but the way they wrote it, it looked like 2025. That's not going to be accepted. That document has to get done all over again. And then you're dealing with situations where there's people in multiple states. I had two of them. The grantor lived to be 105. That's exciting. And then one of them was dealing with people in 3 different states. So one person, the notary didn't put their stamp. So imagine having to get that done over. And they've been dealing with this since April. So this can go on months and months and months. So something that you think is literally the last part of the transaction that may not be that important, the last smallest detail could be the very most important detail. And that's all I wanted to add to that. If y'all don't have anything else to add, yep. Okay. So, Erica, I wanted you to start us out with this one because you came in talking about occupancy affidavits. So we talked about deeds a little bit. Can you kind of talk about how tenancy may affect when people are setting up trusts?
So hopefully I'm catching what you're pitching here. So the when setting up a trust, we want to make sure that the person who actually owns the property is able to convey it into the trust. If we've got, let's say, a life estate deed with no powers, which means that person has no opportunity to transfer the property, then we can't do what they want us to do, which is transfer it into a trust. I've seen with deeds a couple of issues where it really should have been notarized. There were issues coming from the attorney, coming from the way it was notarized. But also, if I've seen it where the deed was incorrectly tracked, where it wasn't somehow it was skipped the way it was supposed to go, and it was like the mom and the boyfriend to just the mom, and it it skipped that portion, and it went from the mom and the boyfriend to the mom and the daughter somehow. But the boyfriend didn't sign or do anything, and that was notarized. So it's just simple things like that where you've screwed up a deed now for titling, and you've got to go back and fix it. And maybe mom's dead at this point. Maybe boyfriend's dead, and you've completely which did happen, we ended up having a huge title issue, having to go back into potentially 2 deeds and fix them for generational issues.
And then Tara, can you touch on it a little bit more? If everything is done and it may or may not have been done correctly and it gets to the register of wills or land records to be recorded as a deed, and then they see a mistake has been made, is that undoing everything and having to redo everything? How does that process work once it gets to where it's supposed to go, but then it has to be done over? Can you tell us a little bit more about that?
Yeah, generally, if they see a mistake, they're going to reject it. They're going to reject the recordation of the deed. They're going to send back to us, and then we're going to have it all re-signed and re-notarized. So it starts the whole process over. And then if you're in a jurisdiction such as Baltimore City or City of Annapolis that requires lien certificates, we've paid $55 for a lien cert, and that's only good for, I believe, I don't even know. Is it 30 days, 60 days? It might be 60 days. So if you don't get it back in within that 60 days, now you have to pay another $55 to do another lien cert, and it kind of starts the whole process over again.
And Savannah, I know you shared your story with the colleague that passed on that situation to you. Do you have anything else to add for what may pose as a challenge?
No. It was covered perfectly.
Okay, perfect. All right, and can you go on to the next slide for me? All right, so we talked more about fraud than I actually imagined would come up. We haven't touched on the digital era as yet. So can you talk a little bit about how trust and wills, especially with remote online notarizations coming about? Can you talk a little bit about compliance and accuracy? Tara, I'll have you touch on compliance first.
I mean, I don't really have much to add other than what we've already kind of gone over, but just to make sure that everything's done accurately, that, you know, you are actually witnessing the person signing, that they're in your presence, that you're recording recording the transaction, you're getting their identification and verifying they are who they say they are. The digital, right? And I'll have Stefan and Erica maybe talk about the digital copies. I have not. I only did a couple of the virtual notarizations during COVID, but I don't have a lot of experience with that because we do everything in person or through the mobile notary. I do anyway.
And I like that you mentioned that, because I know in Maryland some people don't want to be remote online notaries. So it's good to know that they have firms that's out here that prefer to keep things traditional. Stefan or Erica, do you have anything to add or touch on with the digital?
So I would say with the digital, I think we've covered just what the general dangers are with notarizing documents. I think those same issues extend to the digital world. The thing that's kind of glaring out at me is that there might be some kind of issue. I'm not sure where I fall if the online notary should keep a copy of the document or immediately destroy the document and record that they, that they performed the notary, right, or the notarization. I'm not sure where the ethical, guidelines are with that. But I would just say, just as an attorney, I want to make sure that whatever, especially if it's like a trust document that otherwise, is supposed to be kept secret, safe, and secure, that there isn't kind of this permanent digital trail of the instrument, because that would go completely contrary to what the spirit of the document is. And that's not something that you necessarily have to deal with or worry about as much with an in-person kind of, on the spot notary. And so that's kind of the thing that, I guard against, just what kinds of documents am I submitting for online notarization.
Yeah, no, I'm with Tara. I am an in-person person, where possible, just because of the nature of the documents we're talking about. I totally see the space for digital, and especially during COVID, and especially when we were in lockdowns and things were there. But I mean, the requirements of having to physically angle the camera to be able to see the signature, to seeing them put it into the envelope and sealing the envelope. You know, it's just so rife with the ability to manipulate those documents and to change those documents, that, you know, I'm on the fence about the digital copies, because, you know, how, other than, I guess you could show, you have to keep the recording. So you could show the recording of what they signed and what you can see in your camera versus what's being presented, in whatever situation is there. So you at least have that. And then being entrusted to keep it safe. I mean, you have the companies that you're supposed to use. So, you know, you're relying on those companies to keep those documents safe and those recordings safe and private. That's just a lot of responsibility that I'm, as an attorney who was a notary, I wouldn't want to have. I like my little book, and you know, I like my safeguards that I've seen the document and I'm good at that point and I can walk away from it.
See, y'all are my people. That's why I do my classes the way that I do, because I feel like a traditional as a notary, you have to be in person, face to face. So even having this whole virtual class, this is new for me. So y'all are my people. I like y'all. All right. Can you go to the last slide for me, please? All right. So this is going to close us out before we get into some questions. Just as an open forum, can y'all talk about any emerging trends that notaries may want to look out for? We talked a little bit about networking, but now would be a good time if you wanted to get a little bit more into how to network, what type of events you should go to. Tara, can you start us out?
I would probably say, you know, really, there's some estate planning councils in the various counties in Maryland. So those might be good places to go. I know I belong to the Anne Arundel County. I think it's the Anne Arundel Estate Planning Council. And really just reach out. I think just reach out to, like you said, maybe local bank branches that might not have notaries available, or and then local attorneys, estate planning attorneys, business attorneys, you know, all types of attorneys need mobile notaries. So especially estate planning, because we have a lot of elderly clients, many of whom are housebound, homebound, or just not mobile, and they're not able to get into our offices. So there's a large need for those for your services.
And I'll piggyback off that and say, you know, nursing homes, you know, you got to be careful with that, but I would say nursing homes, places, you know, senior centers, there's legal conferences that you can go to, CLEs, which are continuing legal education, where you can set up a booth, usually for minimal cost. But the easiest way is, as Tara said, to call attorneys. We love food. If you bring us cupcakes, we will remember you, and we will probably hire you. You know, we love treats and things like that. So if you bring us treats, we will remember you. Bring some business cards and, you know, show us what you got. And we'll definitely use you.
I concur, and I have nothing to add to that. I think, you know, all of that was said very perfectly.
All right, love it. All right, so if you go ahead and go to the last slide for me. So everybody, if you want to turn your camera on, you can go ahead and turn your camera on, and we'll do some questions. So the first one that was in the comments was, it was addressed to you, Tara, but if y'all want to do it open forum style, the question is, what happened to the property when there are no more blood relatives?
Yeah, I think we were talking about trusts and wills. If there are no other blood relatives, certainly you can leave your assets to anybody you want to. You can leave them to your neighbor, your best friend. You can leave it all to charity if you have no blood relatives left. But that has to be in writing. So you have to say that if all of these people that I want to receive my my money and property do not survive me, then in that case, I leave all of my money and property to whatever charity you choose or whatever friends or other people that you want to leave your money to. If you don't do that, then Maryland has a statute. It's called the intestate succession, meaning you don't have a will, it's intestate, and that says where all of your assets go, and it sets up the family tree, and then that's what you have to go by.
And should that be handwritten or should it be in a legal document?
It should be in a legal document, witnessed and signed.
Okay, perfect. And then I'm gonna throw out the second question to you, Erica. Not necessarily being on your deathbed, and it may or may not be an emergency situation, but when older people are opening trusts, would that be considered a red flag?
Not necessarily, no, because generally speaking, they're looking at Medicaid. When they're looking at a trust at that age, they're looking at Medicaid protection because they're looking at the cost of having health care or long-term care or any care at this point in a nursing home, with it being like $10,000, $13,000 a month. And they want to qualify for Medicaid. So they may be looking at a trust for that purpose. And typically everybody puts it off till the end. So, that's not necessarily a red flag. Now, if they come back to me and say something completely different the next day, yes, red flag.
And then, Stevan, my question for you, because I know you be on social media and in these notary streets, there's a new certified trust agent certification, I think it's called. I might be saying it wrong. So does it matter if the notary, and I know this is just your opinion, full disclaimer, it doesn't appeal to the views of everybody, but as an attorney for you here on my panel today, does it matter if the notary has any additional special certifications that are specific to a specific niche or just in general?
No, it's a flat no for me, only because the notary needs to be able to do what notaries do, and I need to be able to do what I do. I'm not sure what certification you just named, but it does sound like it involves the notary having some kind of trust experience, maybe, or experience with the substance of trust. I really don't know what it is, but I would say no. What matters to me is the notary personable? Does the notary know how to notarize? Is the notary, certified in being a notary? And can they be reliable? Can they show up when I need them to show up?
Yeah, I'm on the same page as Stevan. I don't have anything to add.
What about you, Erica?
No, flat no.
All right, so I'll open up the forum if anybody has any additional questions. But before I let y'all go, you have to share. Give me one crazy notary story that you had. You could start, Tara.
I know. I don't have any. I feel bad. I don't have a crazy notary story.
That's understandable because I'm like that too. I don't get the crazy stories that everybody else gets, so I get it. Do you have any to share, Erica?
Not that I can think of. I'm sure I've seen something crazy. And because we get walk-ins to the office who, can you notarize this? And we always say no, because we only notarize for clients. But, I'm sure if I would have accepted it, it'd probably be something crazy like that. Like, can you sign this for me for my grandma who's in her bed, yada, yada, yada. Like, we get things like that where they call and ask us if we will notarize something. Like I have gotten that call. Grandma is at home. Can you notarize this? And we flat out say no. Like we're not going to do that. I've been asked to transfer a house for a personal representative before, because that's what they would have wanted. Mom and dad would have wanted this to happen, and they're incompetent. Definitely didn't do that. So, usually I guess I don't say that it was crazy, but more fraudulent stuff. I don't know. What do you hear? I mean, what's crazy that you're hearing out there?
Stevan, before you answer, can you go to the next slide for me? Do you have any crazy stories to share?
Not anything that I haven't already shared. I feel like, you know, I do my best to not put notaries in precarious positions, because I just know that if the notary is in a precarious position, that means that I'm in a precarious position, and I'm not trying to even flirt with danger when it comes to something as simple as executing a document. So, I mean, I think attorneys in general have a very, very low tolerance for, you know, foul play when it comes to just formal things like getting things signed off on. So there's not really, you know, I think a big issue in terms of either you know that you're not supposed to be doing something, or you know, or you don't know. And I mean, that's as simple as that gets.
So I think it covers the whole range, going from the fake IDs to forged signatures to people showing up, and then they had one conversation before the appointment, and then you get to the appointment and it's a whole nother something else, and people changing their minds, and they going through divorce case, and now the other person want to act like they don't know what's going on with this paperwork.